Good evening, ladies and gentlemen, and welcome to the Board of Supervisors meeting of Tuesday, March the 3rd. Ms. Steele, would you call the roll?
Dr. Orth?
Here.
Dr. Leming?
Here.
Mr. Hutson?
Here.
Mr. Chriscoe?
Here.
Mr. Nicosia?
Here.
Ms. Hanson?
Here.
Mr. Bonniville?
Here.
All present.
Thank you. All that are able, will you please rise for the invocation and the Pledge of Allegiance? The invocation will be by the Honorable Tony Nicosia, and the Pledge of Allegiance will be given by Ms. Haley Ross, Bodytut Elementary.
Let us pray. Heavenly Father, we thank you for this day, Lord. We thank you for this opportunity to come together as a Board of Supervisors and citizens of Gloucester to conduct and listen to the business of Gloucester County. Go with us, be with us, as always. In Jesus' name, amen.
Makes it green, and you're going to say the Pledge of Allegiance, okay? Okay, here we go.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all.
Thank you very much. Next up, we will look for an adoption of the agenda.
So moved. Second.
We have a motion, we have a second. Any further discussion? Seeing none, all those in favor, please signify by saying aye. Aye. Next up, we will have the approval of the consent agenda.
So moved. Second.
We have a motion and a second. Seeing no further discussion, all in favor, please signify by saying aye. Aye. Next, we will move to matters presented by the board.
Mr. Chairman.
Yes, sir. Dr. Leming.
Let me turn my mic on. Mr. Chairman, I have two items to bring before the board this evening. Many people know, because there's been a lot of fanfare about the potential redistricting that's before the Commonwealth of Virginia and currently before the Supreme Court of Virginia. As the board is aware, this board does not have the constitutional authority to affect the function of the electoral board or of the registrar. I believe that's correct. What I would like from the board this evening is the board's permission to have board counsel submit a request to the Supreme Court of Virginia seeking permission for the Gloucester County Board of Supervisors to draft and submit an amicus brief on the matter. Was that said correctly, whether you agree or not agree?
It was said correctly, yes, sir.
And I think we all received this in an email form from Dr. Leming. If there is a head nod, we can move forward. That's all it would take for council to work on this, correct? Or you want a motion?
Mr. Chairman, can I just ask?
Absolutely.
A lot of constituents may not know what that is. So would it be okay with Mr. Lemon just give a brief description of what that would be to presenting that what we're talking about? Because I did not know what it was either before, and so.
Supervisor Shannon, I give you a disclaimer before the world that I was accepted to law school and never attended a single class. So with that statement, I would defer what an amicus brief is to someone who has taught law school.
May I, Mr. Chair? Thank you, Dr. Leming. He didn't say anything wrong, so it was all correct. An amicus brief is basically amicus curiae is a friend of the court, which means it's a brief filed by a non-party in a case. There is on appeal a case to the Supreme Court of Virginia dealing with, out of Tazewell County, whether this election coming up, the referendum election on April 21st, is legal or illegal. Can it be held or not? Can there be early voting or not? So there are a myriad of issues associated with this matter. It's already on appeal to the Supreme Court of Virginia. The Supreme Court of Virginia has indicated that they're going to let the election go forward. They're not going to rush their decision. They may ultimately decide that the election's illegal. They may. I've researched this fairly extensively, and it could go either way. It really could go either way, and I don't like that, and nobody likes that. But I understand the positions of the parties, and that's not an unintended pun. That's a pun. So I understand the position of the parties. I could, and if you direct me to, I will file a motion to file an amicus brief, a friend of the court brief, a non-party brief. It's not an absolute right to do that. You can't file a brief just because you want to. You have to have permission of the court to do that. I'll do that if you direct me to file the motion. In my estimation, I cannot add anything that will not be added to the fray, to the discussion, to the appeal. I clerked at the Supreme Court of Virginia in 1986. So I was the clerk for Justice Whiting of the Supreme Court of Virginia. And they get a little disturbed when people regurgitate or say the same thing again and again and don't add anything that illuminates or adds to the issue. So I'll file the brief or the motion to file a brief if you direct me to. So is there another question?
What I was getting to is the purpose of it. Like, what would that do if we filed it with them? What does that say to them? What is the purpose of the amicus brief?
Well, the purpose would be to support one side or the other, and I'm assuming that correctly that Dr. Leming's purpose is to support the position that this is an illegally held vote on the referendum. So the purpose would be to support that position. But you can express your support other ways, but I'll do whatever you want.
It was my understanding, Dr. Lemon, that it wasn't just about the legality or constitutionality of the amendment that's in front of the Supreme Court, but that it was also possibly also disputing the taxpayer burden of such address that this was putting on Gloucester, particularly. Am I incorrect?
Mr. Chairman.
Yes, please.
At the moment, before us is only the matter of Mr. Wilmot asking permission of the court to submit an amicus brief. That's the only question currently on the table.
Sure.
But I think as Ms. Hanson alluded to, and Mr. Wilmot, you're just asking for an opinion, but you're not asking which way you want it posed. That it is illegal or it's not.
Mr. Chairman, my understanding is at the moment we don't have that opportunity to weigh in either way. In order for anyone to supply an amicus curiae brief to the court has to grant permission to receive that amicus curiae, and we don't have that permission at the moment at all.
That's true, but I know the reason, but yes.
So what is the will of the board?
So
Dr. Leming?
let me, please, I don't want to be non-transparent if that's the question before. If in fact the court were to grant us permission to draft and file an amicus curiae, I would hope that it would be in support of the current redistricting being unconstitutional, consistent with the Constitution of Virginia. Is that clear, Shannon?
And I would caveat, I've gotten a lot of emails, and, most of them are asking for us not to block the vote, which I'm a voter. I wouldn't ever consider that. It's a constitutional right for us to vote. I think really what this brief does is that it puts us in front of the Supreme Court to saying that, we, or as a collective, about the constitutionality of what's going on. That's right. And that we would all agree or not agree about what that's going to be once that is put forth and the Supreme Court rules on it, that we just kind of put our hand in it, that we want them to know how we feel. It's basically a letter to say that we we don't agree. And we'd like you to rule in this favor, so.
Dr. Orth?
Yeah, Dr. Leming, so when this whole plan came forth, wasn't this discussed about the constitutionality at the General Assembly?
I don't know that I'm qualified to give you the recitation of the General Assembly, acts of the General Assembly. However, I believe that the General Assembly set the timeline. They voted on the timeline. In budget, they've committed funds to the timeline to execute that. Meanwhile, in Tazewell County, there was an objection to the constitutionality of what the General Assembly did, and that went on appeal to the appeals court, and the appeals court sent that quickly, correct me if I'm wrong, Ted, sent that quickly to the Supreme Court of Virginia as to the constitutionality of that which the General Assembly had done. That's where we are.
And I do think that we need to remember, and I think some of the discussion is that we as board members are here to protect the Constitution as we swore on our oath, to protect the Constitution of the state of Virginia, and that if we feel collectively as a board that somehow it's being violated, that we as a board should say so. And so that was my other understanding about that as well. So, and it really will come down to that, the vote and or what the Virginia Supreme Court comes down to, but it puts our name in the hat to say we don't agree with it, unconstitutional.
Dr. Wood?
I'm still confused about the constitutionality of this, because I would have expected there was a fair amount of discussion at the General Assembly and that some legal opinions would have been discussed there. I mean, I don't know.
They have missed, the only thing that I have a major heartburn with this, I don't mind them bringing this to a vote. We brought it to a vote in 20 or 21 to set up what we currently have. Bipartisan redistricting done at the census. This is a rebuff by the Virginia legislature to try to counteract what other states have done to go the other way, because they didn't have it set up in their constitution. My biggest problem with all of this is the 90 days from the passing of this legislation. The earliest day you can vote on this is April the 18th. Early voting starts on March the 6th. That is my only concern with the entire thing. If they had made what was the original primary date, the election date, I think this wouldn't be an issue, which was June something. They've now moved the primary date back to August. But there's a 90-day window for a constitutional amendment through this process, which would limit the start of voting to April the 18th. That is why, that is where I've stood the entire time. And now we haven't had these discussions because I thought it was over and done with the first round through the Supreme Court, and then it came back with a different course. And now the Supreme Court is not willing to take it as a urgent matter. Or expedited, thank you. That was the term I could not.
So regardless of what's going on, let's just say that the vote still will proceed regardless on April 21st.
Everywhere except Tazewell County.
Okay.
I believe early voting will proceed.
March the 6th. In every locality in the Commonwealth except Tazewell, they have been instructed to not start. I have not heard that they had released that, but as of right now, Tazewell will not start voting on Friday.
Okay.
This is the last I had heard.
Just like you, Hanson, I've gotten a whole bunch of emails asking that we do not obstruct the vote. That's the concern that many of the citizens expressed to me, and I'm assuming that those same emails came to all the board members.
Mm-hmm. Mr. Chairman, briefly, my motion, if it's called that, my request, has no effect on the vote and has no intended effect on the vote, has no effect on the registrar, has no effect on the electoral board, it has no effect on anything other than to submit and ask permission from the court to submit an amicus brief to the court about the constitutionality and the timing. That's it.
Right.
We're being beholden to. We don't have a choice. We have to proceed. But
we
we
will.
are, we're both saying that we think that it's unconstitutional, at least we put our marker in the book with them as far as that's concerned.
And that's if we get the permission and actually have to file anything, correct?
Yes, sir. May I?
Absolutely.
I do want to cite Rule 3-1 of your Rules of Procedure. No item presented under these headings will be acted upon at the meeting at which it was presented unless it's the unanimous consensus of the board. So it's an out-of-order motion unless all of you agree.
Good.
Mr. Chair.
Mr. Nicosia.
I want to reiterate to the citizens, I'm not going to stand in your way to go to the poll. I hope that you go, and I hope that you cast a vote. I have read every email that has come my way. I have fielded every phone call, and I have not responded to everyone, but the ones on the phone I have, and I have told every person who's called me, go to your poll and cast your vote. That's your right. But at the same time, I support my fellow board members that we're just doing what we said we would do, which is hold up the Constitution.
Yep, Mr. Bonniville.
Since I'm the only one that hasn't spoken, I too would echo those sentiments. I don't think it's our place to stop the vote by any means. I just think it's our place to make sure that what's in the Constitution is what's being followed, and I would agree with what Mr. Leming is requesting.
Yep. If there is a consensus, if any board member wishes not to, then we won't move forward, but if there is unanimous consent, we will have Mr. Wilmot do that, and that's... Right.
What do you see as the pros and cons? Do you see a need for it, Mr. Wilmot? I mean, you're counsel. We take your opinion.
I understand Dr. Leming's position, and I understand the legal arguments. I understand the desire to weigh in on behalf of Gloucester County, that Gloucester County, the majority of the elected leaders of Gloucester County may consider this to be an unlawful election, to give the opportunity to redistrict in a way that shouldn't be done in the eyes of the people who are objecting to it. I understand all of that. But to answer your question, as self-important as I am, and as brilliant as I think I am, and I do, and I am, I don't think I could add anything to this. So other than Gloucester's on record as objecting. But that isn't what an amicus brief is. An amicus brief is to enlighten the court, is to tell the court things they didn't know. They're going to know all of that. So I don't think you should do it, and you can't do it tonight because your rules say you can't. The deadline to file an amicus brief motion is March 16th. So if you'd like me to do that, you can direct me to do that at some other meeting.
Okay. If we want to continue this, if y'all let me know, we can add it to the agenda for March the 9th.
Absolutely.
Okay.
And I'll be here with bells on.
Yep. Then that's what we will,
Close also.
yep, we will do that as well. Okay. Dr. Leming, you said you had another item.
Yes, Mr. Chairman. I think this is more of a policy statement, and if anybody sort of wants to take issue with me, they can. But I think before this board, December 3rd, 2019, was a resolution by the Gloucester County Board of Supervisors affirming that the county would be a Second Amendment sanctuary. That resolution was reaffirmed June the 1st of 21 by a vote of 6-0. I've been contacted by a variety of people and asked to bring this matter back up before the board and I have chosen not to bring the matter back up before the board, but I have told those individuals on the phone and in email that a board's already taken a position on this, and that we don't need to retake another position on it, that it's the policy of the board until it's voted down.
Correct.
Thank you, Mr. Chairman.
Yes. Any other board members? I just have one quick one. Next week is an emergency preparedness week. There will be a tornado drill and everything else next Wednesday from emergency management. Staff will be being notified about that, but just want to make everybody aware of that as well. Seeing no others. Oh, Dr. Leming.
I'm just looking at the agenda. Mrs. Callaway, were you going to make an announcement about the responses to the RFQ, or do you want, can I do that? You go for it. Okay. Mr. Chairman, I spoke earlier today with Jay Hobbs, and I also have spoken briefly with Mrs. Callaway, and I'm pleased to report to the board and to the public that the County of Gloucester has received 9 responses to our request for qualifications by 4 p.m. today, which was the cutoff. So these are not people, these are now people of my understanding who are being considered to be qualified. They'll be scored in order to create the most appropriate, not necessarily the lowest cost, but the most appropriate contractor to bid the project. Is that fair? Thank you. Thank you, Mr. Chairman. I was just very excited about the number 9, to be frank with you.
No, that is nice. It's comforting. Okay, seeing no others, Ms. Steele, County Administrator.
Yes, just a quick reminder that if the board has an opinion on the draft policy for facility uses, that is a county administration policy, but we discussed about changing that to allow signage during early voting, and I've only heard from a couple of you all, and it is like right around the corner, so I'd like to get that information out in social media release. Also, some of you may have already heard this, but Lee McKnight, our resident engineer, sent out a notice that he will be doing a temporary assignment in Fredericksburg, and that will start on March 25th, and not having an ending date. And thank goodness he's got Drew, who is his assistant, who's been fantastic to work with, but I've already told Lee we want him back as soon as possible. And then I am very pleased to introduce to you, and if I lost him, there we go, Travis Wolf, who is our new IT director, if you could stand. And Travis comes to us directly from King William County. He's also worked for Timmins, and we are just, he was the director of IT there. And we are so excited to have him here, and he's already just jumping right in like we want him to.
Perfect.
Thank you.
Welcome, sir.
That's all.
Mr. Chairman,
Dr. Leming.
Ms. Steele, can sort of time is of the essence on your first topic.
Yes.
Yes.
Do you want a consensus nod today?
Yes, if there
I
are
mean,
no changes.
time is of the essence because it's Friday.
I responded, but yeah, that's,
All good? Okay.
I'm good. I just wanted to hear you to get the message. Civil rights trail.
Thank you. And Mr. Hutson reminded me that we had a wonderful announcement and celebration that Gloucester County has been added to the United States Civil Rights Trail. And so a number of the board members were able to attend, and it was a very special event, and we're very excited about what it means for the county and the recognition of our history and helping spread that history. So thank you.
okay. Next, we'll move to our scheduled presentations. Our scheduled presentation tonight is an update from Sheriff Darrell Warren.
understand it's been some bets on what I'm here for tonight. Mr. Brown even asked me at Jersey Mike's tonight if I was here to try to buy something. So thank you for the opportunity to speak. The agenda item was very brief because this discussion is concerning an ongoing investigation that the Sheriff's Office has been involved in. Sometime around the spring of 2025, we started fielding complaints regarding are vape shops in the county. And the complaints range from potentially underage minors purchasing vape products to questionable items itself being sold. So in the summer, I directed our narcotics investigators to launch an investigation into the business practices of all of our vape cigarette shops in the county. So since that time, investigators have made several undercover purchases from each of these businesses. As you are most likely aware, it takes months, I say that months, to get state lab results that shows us exactly what the chemical compound are of the products that we have sent in. So today, based on the results that we do have, the Sheriff's Office, supplemented by members of the Tri-Rivers Drug Task Force, conducted a large-scale operation today which involved the execution of 5 simultaneous search warrants at the following businesses: Rhino Cigars and Vape, located at 1751 George Washington Memorial Highway. That's located in Gloucester Point Shopping Center. The Vault Vape and Hookah Shop, located at 1720 George Washington Memorial Highway. That's almost directly across the street on the southbound side. Rhino Tobacco and Vapes, located at 7106 Hayes Shopping Court. That's in the Kroger Shopping Center. Super Tobacco and Vape, which occupies 2 addresses. It's a very large store, 4750 and 4752 George Washington Memorial Highway. That's in the shopping center where Little Caesar's Pizza, I think Doodle's Donuts is in there, just south of White Marsh Shopping Center. And then finally, Rhino Tobacco and Vapes, located at 7479 Hargett Boulevard, which is across from the hospital and the Food Line Shopping Center. During our searches today, we seized over 2,400 items that we believe to be unlawful. What we discovered during this investigation is that these 5 stores are selling products that contain a Schedule I narcotic. A Schedule I narcotic is defined as substances or chemicals with no currently accepted medical use and has a high potential for abuse. Some examples that I'm sure you've heard of Schedule I drugs are heroin and LSD. The possession alone of Schedule I narcotic is a Class 5 felony. When this investigation was launched, we met multiple times with members of our Commonwealth Attorney's Office and formulated a game plan before the execution today. At this time, only 1 arrest was made for providing false identification to law enforcement. We're conducting interviews, going through electronic and physical files that were seized today, as well as awaiting additional returns from the state lab. We received a result as late as this morning from the state lab, which came back as a Schedule II narcotic. So once we've had an opportunity to basically review everything involved, we'll consult again with the CA's office to again consider the appropriate charges. Here's what I can share with you this evening. All 5 of these stores have been and are continuously selling Schedule I narcotics. Today, we seize those same items from all 5 additional stores that will be ultimately tested, but we know with reasonable certainty that these will contain Schedule I narcotics. I have 2 handouts that I'd like to share this evening. One is a few pictures. Mr. Wilmot, you can pass those out. And one is a copy of the county code, which really is why I'm here this evening. I would ask each of you to direct your attention to Section 10-23 of the County Code, which states, any license issued pursuant to this chapter may be suspended or revoked by the assessing official or the Board of Supervisors for any of the following reasons. Letter B, any reason which would have denied the issuance of the license. I feel confident that we wouldn't issue a license to a business that was coming here with the intent of selling Schedule I narcotics. Although I support and welcome businesses to our county, I firmly believe that we shouldn't want businesses here that are selling poison to our citizens. I'll be happy to answer any questions regarding this, but please keep in mind this is a very active investigation. I'm giving you brief results. I'm giving you brief details, and I really can't dig much deeper into how we've got to where we are this evening. But I would ask you to seriously consider suspending the business license of these 5 businesses.
Let's make the motion.
I was getting ready to do that.
Go for it. We'll make the motion that the license for these businesses,
Mr. Wilmot, before we make a motion that we can't make
Oh,
or take action on.
first, it's not on the agenda, but, because I just did that, the other one. Yes, on the 9th. Yes, sir, Dr. Leming. But secondly, the sheriff and I met, so this is not a surprise to me. And I didn't spill the beans, which is good,
I appreciate it.
right? Even to my wife, that's pretty cool. Yeah, we met him at the vape shop. No. I did not. The sheriff is correct. Everything he said is correct. In order to revoke or suspend a business license to which some kind of property interest probably pertains, one should get notice and an opportunity to be heard under the Due Process Clause of the United States Constitution. We talked a lot about the constitutions. I'm a firm believer in them. They're a good thing. So I think the proper procedure would be not to do anything tonight other than to schedule a hearing before this Board of Supervisors to consider whether to revoke the business licenses of these 5 establishments. Give the proprietors, owners, notice of that hearing and an opportunity to be heard, because that's what due process is all about, Charlie Brown. Due process is all about notice and an opportunity to be heard. It might not change things, but for the board to act tonight, I think would be, in my estimation, a little premature, and not to protect the constitutional rights of the businesses involved. So my recommendation is that this board set a hearing within the next 2 or 3 weeks, give notice to the owners and proprietors of these establishments that you are setting this hearing and you're considering whether to revoke or suspend their business license. Let them attend and say whatever they want to say. It may or may not change your mind, but I think in the long run, it will give the board a more defensible position were you to decide to suspend or revoke their licenses. So what I recommend is that you set a date in the next 2 or 3 weeks now, and give notice to the proprietors and owners, and we go forward. You could suspend their licenses in the interim. I don't recommend that. This has been going on for a considerable period of time. They know they're under the microscope, so to speak. Could something else untoward happen between now and then? Yes, it could. But the downside here is that if you were to revoke or suspend their license tonight, you could be faced with some objection and some kind of suit, which I'm happy to defend. But I'd rather not. I'd rather you give them their due process rights to defend themselves. So could you set a date in 2 or 3 weeks that we can all attend and then we can hear this?
Mr. Chairman,
Dr. Leming?
I think that echoing what counsel has said back to him, I think the most appropriate thing is to put an agenda item on the March 9 meeting to set a date. I will add that as a business owner, I agree with Mr. Wilmot that there are property rights that are attached to my business license. And I would cringe personally if someone were to give me less than 30 days notice to retain counsel to defend my property rights. So I just like the item to notice people, to potentially notice people with the with a majority vote, that agenda item to be on the next meeting. And that agenda item, I think, ought to have sufficient time to represent due process. whatever council determines what that is.
I just pulled up our meeting calendar to try to look at what would make sense. To your point, probably the easiest and the cleanest is to add it to our April the 7th meeting. That way we don't have to wait till the 9th to set it, because we can go ahead and direct staff to put that on our agenda for the 7th. I wouldn't feel any, if we wanted to do it sooner, I would say we have a budget work session on March the 26th, which is 3 weeks and 2 days that we could add at the beginning. But I think the cleanest and the easiest is to add it to the April 7th meeting for discussion and decision and hearing whatever we need to do. Yes.
So, Mr. Wilmot, so what is the downside to just temporarily suspending it? Well, I mean, you're talking about allowing this business to stay in motion and doing what they're doing until we can make, do all of these things. So I need to understand that. Because I mean, effectively letting them stay in business without giving any pause to that. And I'm a little uncomfortable with that.
The downside is that if ultimately we were not to prevail, then the county could be on the hook for damages associated or with the loss of profits. And what I look at when I have a problem that's gone on for years and years, apparently, or years, I have a hard time understanding the immediacy of the danger if it's gone on for a long time. So if something started yesterday and it was terrible, then I would say, well, let's shut it down now. But if I have something that apparently has been going on for a long time, I have a harder time understanding the immediacy of the situation. And if these establishments know they're under the microscope, which they will, or they should, I don't want to use the word raided because that's wrong. They were subject to lawful searches is what they were. They were subject to lawful searches today, which revealed potentially damaging evidence, from their perspective. I don't see the necessity, given that they know they're going to be under the microscope and that this has been going on for a long time, that you have to take action tonight to suspend the license. You may. It says you may. The code says you may. So you may do that. I just wouldn't, because ultimately, if y'all were to decide, wait a minute, this was one rogue employee, they might come in here with their representatives, and they might convince you that this was one bad actor, or 2 or 3 or 5 bad actors, or this was an isolated thing, that you might not want to revoke their license. So I think there's a reason why due process requires notice and an opportunity to be heard, is because you should be heard. You should be listened to. So I would recommend you not suspend their license, but I can see why you'd want to, because according to the sheriff, they've been violating the law. So you can go either way.
The thing is just because we discovered it just now, we've discovered it now. It's been going on. How many years did Luty's Lair go without, getting in, constantly being investigated or whatever until they finally were shut down? So,
I think we, meaning the sheriff's office, discovered it, has been discovering it over an extended period of time. But the sheriff's office has to have the evidence to proceed, and they're proceeding with their criminal prosecutions. But this goes hand in hand with that. So it's been over a period of time. Yes.
Dr. Leming.
I want to try to bridge the gap. I sense Supervisor Hanson, excuse me, I apologize. So I still like my first motion, by the way, and whether that's April 9 or it's March 26, whatever. Is there a way to put a temporary term and condition due to the exigent circumstance? And that term and condition would be the prohibition? against the products so referenced?
Well,
That already exists in state code.
State code.
Oh.
It's a felony. It's a
So
state-
in other words, it would be that you can't do what's illegal.
You can't do what you've been doing.
You
You can't do what you do, okay,
You
all
can't
right.
keep doing illegally what you've been doing illegally.
Are they going to be open?
I want to make sure I go on a record here tonight, and I completely understand Mr. Wilmot's position. He and I had great discussion today. I think it's absolutely absurd that I'm here tonight and I'm telling you that they're selling the equivalent to heroin in an open storefront, and we're going to worry about their due process and I know they have due process, I get it. But if I arrest a drunk driver tonight, I'm going to put him or her in jail until they sober up, without their due process, right? They're going to jail because we believe that they're driving under the influence. We got probable cause, we got an arrest warrant, they go to jail. They may go to court later and be found not guilty, but they sat in jail for 8 hours without due process. This is a much more serious offense. You can see by the pictures in this. We went through this back when they were selling spice and bath salts. They're marketing this stuff fancy, colorful, flavorful. And I understand what Mr. Wilmot's saying, it's been going on. But I also want to make sure that everybody's clear that the sheriff's office hasn't been sitting on their hands letting it go on. We have to have state lab results before we can take action, which is what has led us here today from our summertime submissions of these products. It takes months. And I know that the products that we bought today are going to take months to get back. But there's no reason at all for me to believe that a same item that I bought 2 months ago that contains a Schedule 1, if I buy the same exact item today, that is not going to contain a Schedule 1. And the idea of a rogue employee coming in, we seized 2,400 items.
Over 5 stores.
2,400 items from 5 stores. That's a ton.
Mr. Chair, and you already have lab results that have stemmed
I
back
have
already?
multiple lab results
That's all I
from
need.
all 5 businesses.
Yep, that's all I need.
So, Mr. Wilmot, question for you. If the board was of the mindset to suspend this license until a hearing date, how would we go about that this evening?
You just vote tonight. But make sure we have the names, because I understand there's 6 establishments, right?
There's
But
5.
only 5 that are culpable.
Yes, I believe one.
You said there was one today.
That's correct. That's
that
correct. There's
is
one
clean. So they're going to do some good business, because they're clean. Okay. But the 5, we're going to have to make sure that we identify the 5. You could suspend the 5, you can do whatever you want. But you could suspend the 5 pending your hearing, whether to revoke it. Yes, sir. I understand why you would do that.
So,
Make the motion. Sheriff Warren, can you name the 5 with addresses?
Yes, again, I did it
I know.
earlier, but
Would you do
I'll
it
be
again?
happy, I'll be happy to. Rhino Cigars and Vape, located at 1751 George Washington Memorial Highway, Gloucester Point Shopping Center. The Vault Vape and Hookah Shop, located at 1720 George Washington Memorial Highway in Gloucester Point, almost directly across from Farmwood Road on the southbound side of George Washington. Rhino Tobacco and Vapes, 7106 Hayes Shopping Court. That's in the Kroger Shopping Center. Super Tobacco and Vape, which occupies 2 addresses, 4750 and 4752 George Washington Memorial Highway, which is the strip mall just south of White Marsh Shopping Center on the southbound side. And then finally, Rhino Tobacco and Vapes, located at 7479 Hargett Boulevard, which is a Food Line Shopping Center across from Walter Reed Hospital.
I make the motion that the 5 establishments listed by Sheriff Darrell Warren have their business license denied, suspended, pending court case.
Pending the hearing set for
April 7th, 2026.
Second.
That gives everybody a month. Any further discussion, questions? Ms. Steele, would you poll the board? We got a second. Mr. Bond will give you the second. Oh, Dr. Leming?
Okay.
Sheriff, I just have a question.
Yes, sir.
Are the business licenses so referenced in the names named? If I go on the State Corporation Commission's website and I look for an agent, do you understand that there are businesses which function?
I do understand. And I can tell you that some of these shops are tied to others.
Right.
And I can't answer that with 100% confidence exactly what each of them are named.
I'm just concerned a little bit.
Dr. May I?
Yes,
Mr.
please.
Sheriff? Dr. Leming, the sheriff and I talked about this, and that was the next step, and I don't like to go next steps because I just like this. But yes, sir, we will be getting notice to the owners and the registered agents and the LLCs and the corporations and everyone involved will make sure that they are noticed for April the 7th, 2026. Now, at that time, they'll come in and be able to talk to y'all. And so you should, at the April 7th meeting, be prepared for an hour or two to be devoted to this particular subject.
Correct.
Because that's what they're entitled to.
Correct.
An hour or two, right?
Thank you, Mr. Chairman.
Yes. Any other questions, comments? Ms. Steele, would you please poll the board?
Dr. Leming? Yes. Mr. Hutson?
Yes.
Mr. Chriscoe?
Yes.
Mr. Nicosia?
Yes.
Ms. Hanson? Yes. Mr. Bonniville?
Yes.
Dr. Orth? Yes. Motion carries.
Can we make sure that this motion gets its way to the Commissioner of the Revenue, who is in charge of the business licenses? Because she needs to know that they've been suspended. Thank you.
Mr. Chairman?
Yes, Dr. Leming.
My assumption is, and for clarity, that the resolution was effective immediately.
Yes. Yes, we should make sure that it's noted that it's effective immediately. Dr. Leming has a very good point.
If I can just take the opportunity real quick while I'm here. I'm joined tonight by Lieutenant Steve Perry. Steve, if you could just stand. He was tasked with overseeing this investigation. It's been very complex. We actually had one of our investigators who was working in this retire at the end of last year, and we had a promotion to fill his spot, and it was a seamless transition. But Steve, thank you for overseeing that. Thank you.
Yep. Thank you, Sheriff.
Thank you.
Thanks.
Next, we have no public hearings tonight. Oh, sorry, public comment. Yeah. So, sorry, we will move now to public comment. Speakers, when you come forward, please state your name, your magisterial district. If you have sent in an email and you are going to speak here tonight, and you speak tonight, your email will not be read in the meeting. If you have emailed and you are here, you can have your email read. Just so you are aware of the rules. I know we have a few emails and a phone message as well. So please come forward, state your name and magisterial district, and limit your comments to 3 minutes.
Good evening, Chairman, members of the board, and fellow residents. My name is Pam Garner, and I serve as one of the co-chairs for the NAACP Gloucester branch. I'm supposed to give you my magisterial district, but I think it's Abingdon. Is that right? Okay. The NAACP Gloucester branch is doing a Pathways to Leadership program, and I will pass along these flyers so you can have a copy of them if you haven't seen them in your emails. The Pathways to Leadership is a civic education initiative designed to strengthen public understanding of how local government functions and to encourage broader community participation in the decision-making processes that shape Gloucester County. The program consists of series of 1.5-hour seminars featuring all our local elected officials and government leaders who will share information about their roles and responsibilities and the avenues available for citizen engagement. The program is open to all residents with both in-person and virtual attendance. Our anticipated outcomes is that we expect to develop citizens who understand the structure and functions in our local government, the increased civic engagement across the county, to strengthen the community networks and partnerships, and establish a repeatable model of future leadership cohorts. We want to empower people of all ages to step forward, to get involved, and help shape the future of Gloucester County. This program is designed to build confidence, expand understanding, and open doors for meaningful participation. I invite you, your students, your families, and when I say students, mean ages 13 and over, your families and your neighbors to join us for this important community effort. I would also like to extend a formal invitation to each of the Board of Supervisors to join us in the upcoming session on Thursday, April the 23rd. The details are in your email as well that was emailed to you during the week of February 25th. We will be honored to have your participation. The program won't be successful without you. Your presence and insight are essential to helping residents gain a clear understanding of the work you do and the impact of local governance. For additional information, residents may contact us at gloucesternaacp@gmail.com or by phone at 804-286-6553. Thank you for your time. Thank you for your continued service to Gloucester County. Any questions?
Well, point of personal privilege, Ms. Garner, we have a possible budget session scheduled for April the 23rd. I will get with my board members, and in order to keep it from having to be an open board meeting, we will try to have 2 available if we don't have that public work session.
Okay, would it be better that we move you further down the schedule?
If you could, because we are in budget season until April the 30th.
Okay,
So if we could rearrange for the Board of Supervisor portion, I think we'd be able to participate
okay.
on a Thursday.
All right, so who do I get with to find out what's the best date? Okay, thank you so much.
Yes.
By the way, it's a great program.
Well, thank you. It won't be a success without all of you and many others to participate.
Correct.
Thank you so much.
Yep.
My name is Diane Jones. I am in the Ware District. And 2 things I'd like to approach tonight. Number 1 is the constitutional amendment, which has been worded so that it is to make the districts fair, and it is the entire opposite of that. It would include Gloucester County in the district, which includes Alexandria, Virginia. It would exclude any Republican district except 1. And I would just like to encourage anyone in this county to not read it verbatim and expect it to be true, because it is not fair, it is not true. You must vote no, or there will be 9 representatives from this state who are Democrats and only 1 potential Republican from this state. That is, it's just not fair, clearly. And if it was the other way around, it still wouldn't be fair. And another thing I wanted to approach with the budget meeting coming up, and our sheriff giving his presentation, I would like to encourage the board to start the raises for these people after the insurance raise. Because as soon as you give them a raise, the insurance goes up almost the exact same percentage as you've given them a raise, which is no raise at all. So I would like you to start the raise, find out what the insurance is going to be. If it goes up, maybe you can negotiate something a little bit better in the way of insurance, but don't start their raise after the insurance is in there. Start it, before. Start the raise after, and the same goes for teachers. And that's it. Thank you.
How are you guys? My name is Brittany Monroe. I live in the Abingdon district. I did write you guys a letter, but I'm here, so I'm going to just read it out loud. This request is actually for the Gloucester Point district. I'm here to respectfully request consideration for allowing a small private micro elementary school to operate within the SF1 zoning district, specifically within an existing church facility, Gloucester Point Baptist Church. I am the founder and director of Harvest Salt and Light Academy. It is a proposed K-5 private Christian school designed to serve local Gloucester families who are actively seeking smaller faith-based, mastery-focused educational options. Currently, many families in our county are commuting to surrounding counties for similar programs. As a result, Gloucester is losing both tax dollars and local economic participation that could otherwise remain here. This proposal is not for a large campus. We are beginning with approximately 15 students in year 1, 30 by year 2, with thoughtful growth projected to 60 by year 3. The school would operate within an existing church building that already has adequate parking spaces, established access points, infrastructure suited for community serving use. And from a land use perspective, it would be a low impact daytime use, limited and predictable traffic patterns during morning drop off, afternoon dismissal, no late night operations, no high volume commercial activity, no structural expansion required, existing as it stands within its walls, we would operate. In many communities, educational uses are considered compatible within residential districts because they serve neighborhood families and operate during standard daytime hours. So allowing this use within the SF1 would provide Gloucester families with more educational choice without increasing density or alternating the residential character of the area. Additionally, keeping families in Gloucester supports our local economy. Tuition dollars spent locally will circulate locally, supporting businesses, services, and employment. It also strengthens long-term community stability by giving families confidence that they can both live and educate their children within our county. The school is not being proposed as a commercial retail enterprise. It is a community-serving educational institution designed to cultivate responsible, engaged, service-oriented young citizens in Gloucester County. I respectfully ask the Commission to consider whether a small-scale private elementary school operating within an existing church facility could be permitted and compatible within this SF1 zoning, whether being permitted through a conditional use approval or an ordinance amendment. My goal is not to challenge zoning, but to work collaboratively within the term to meet a clear and growing community need. I just want to thank you for your time and consideration, and I just hope that we can move forward together. I know that there are several preschools here in the county within some of the churches that you all attend.
Ms.
And
Monroe, can you please wrap, your time is up, please.
Okay,
Finish
I'm so
when you can.
sorry.
Thank you.
Just thank you.
Yep, thank you.
handouts. Thank you. Alrighty. So my name is Christina King. I'm in the Petsworth district. I've spoken with Dr. Leming on the phone. So nice to meet you in person. So good evening, everyone. I just wanted to start by saying, first of all, thank you so much for the hard work you do for the county. It is a lot. So all of the details are in the packets. I just wanted to talk about a property that my husband and I bought this property in September of 2025. And the goal was to fix it up and offer a good affordable housing option for friends of ours. It has 2 manufactured homes on it. We wanted to remove the decrepit one and renovate the other one that was in good shape. So we started with electricity. Dominion had no safety concerns at all. They hooked up the power, and my husband and I began minor repairs. And our plan was to put in a permanent foundation to have it converted to real property. While applying for permits, though, it was discovered that the last time lights were on at this address was August of 2023. So it had passed the 2 years of being uninhabited, so it had lost its vested rights literally the month before. So now our only recourse is having the home removed. We can't do a special exception. I've tried conditional use, variance, anything, but nothing in the ordinance allows for that. So our hands are tied, so that's why I'm coming here and bothering you this evening. But exceptions do exist for a reason. So we all would agree manufactured homes aren't necessarily appropriate for all neighborhoods. However, in this particular case, it does suit the general vicinity. As we know, the vicinity is a factor in consideration for all kinds of exceptions in the ordinance, whether it's appropriate or not to the general vicinity. So I know I'm not entitled to anything, but I would like to ask if you could consider making an exception in this case. If you could allow the home to remain, we would like to make a proffer to the county as a one-time amount of $2,000 to the county. I would not even offer this proffer if the home wasn't worth it. The home is not attractive at the moment, but it is in good shape. It's solid. So you can see on page 4 that this property is surrounded by manufactured homes. And on the next 4 pages, you can see all of those homes in the neighborhood, including the one we purchased. It's a purely manufactured home community. So I also would like to ask you to consider a few things. One of the intentions of the zoning ordinance is to promote the preservation of affordable housing. It's in the intent section. So, well, this would be preserving an affordable home that is in good shape. The ordinance even says that if a non-conforming manufactured home burns down, it's given 5 years to be rebuilt as a non-conforming manufactured home again. So even if a burnt down manufactured home is given 5 years, how much more so could you possibly consider something that just outside that 2-year period? Since we want to convert it to real property, it would also be taxed as real property, which of course would benefit the county with taxes in the long run. And there are also some before and after pictures of our own property that we fixed up so that you can be assured that once completed, it would be an attractive piece of property and would beautify the neighborhood. So in conclusion, I'd like to appreciate it if you would be able to consider the proffer of $2,000 so that this home can remain on the property. And again, thank you very much for all that you do for the county. I really appreciate your time and consideration this evening. Any questions? Thank you.
Thank you. Any other citizens wishing to come forward this evening?
Good evening, ladies and gentlemen, members of the board. I am a constituent in the Ware district. This may be a little off topic.
What's your name, sir?
I'm a constituent. I'd rather not disclose if that's okay. I pay taxes here in Gloucester County in the Ware district. The issue that I'm having is that some of the availability for y'all are only through times and windows that I can't participate in, and I'm not the only one who feels that way. As I've called and asked for those things, or are there any other stipulations, I'm referred to technology that I also, unfortunately, don't have readily access to. I'm trying to figure out, is there any kind of mechanism or scheduling adjustment? I'm missing my child's activities this evening to spend this time with y'all. And typically I have to lose time from work in order to come visit y'all during normal business hours. And the library's not open when I typically get home either. So I can't just send you an email. Because of that, and I understand everything costs money, but These are money and financial aspects I don't have means to. So I've communicated this a few times verbally. I've communicated this a few times to some of the people I've been able to reach and make contact with, and I don't know how to get a hold of your scheduling otherwise. So I don't know what else to do from there. Because of that, these meetings aren't received. I don't have any input, and I've been told many times, you guys want participation, you want the input, and then we call and ask why was the decision made, and we were told you didn't receive any input to the contrary. This budget meeting will probably be a good example of that. I don't have any further comment on that, not with the time span that I've been given, but I appreciate your time, and I do not wish to have your role. I appreciate the time and energy you put in. It's just unfortunately it's outside the window in which I'm allowed to participate under normal circumstances. So thank you again for your time.
Sir, before you walk away.
Yes, sir.
If you will write down an address, we can mail you something, or get with Ms. Calloway right here.
Okay.
We can mail you all of our email addresses,
right,
our phone numbers,
right,
and the ability to participate via a phone message in these meetings if you're unable to attend.
Right, but that would be during my working schedule.
Nope, you can call and leave that message as long as you're leaving that message before 4 o'clock the day of this meeting.
Right.
The way you do this and with the instructions, it will be played at this meeting like we're getting ready to play one here in a few minutes.
Fair enough.
But if you get your information to Ms. Calloway, she will make sure you're able to get your information to us and have all of our phone numbers and addresses.
Perfect. Thanks y'all very much.
But to have your message read at the meeting, you have to leave your name.
I understand.
Thank you.
I understand.
Thank you. Any other citizens wishing to come before the board this evening? Seeing none, Ms. Tyler, I think we have a few emails and one phone message.
Yes, Mr. Chair. First one is from Pamela Garner, Gobbler Trace. Bottom line up front, do not obstruct, delay, or interfere with the special election on redistricting on April 21st, 2026. Do not deny my vote. I write to ensure the record is clear and factual regarding your responsibilities in the administration of the upcoming April 21st, 2026 special election on the proposed Virginia constitutional amendment concerning congressional redistricting. Why Virginians should vote on redistricting. The proposed amendment would temporarily permit the General Assembly to redraw Virginia's congressional districts ahead of the 2026 elections. This measure has been framed as a response to recent redistricting actions in Texas and other states where new congressional maps were adopted without a statewide vote. In Virginia, however, this question has been placed directly before the electorate. The Supreme Court of Virginia has allowed the April 21st special election to proceed, ensuring that Virginia's not elected officials decide whether updated congressional maps will be used. Your legal responsibilities. As members of the Board of Supervisors, you are agents of the Commonwealth. Under Article 7 of the Constitution of Virginia and the Dillon Rule, counties, cities, and towns are administrative arms of the state and may exercise only those powers expressly granted by the General Assembly. Election administration is governed by state law. Virginia provides a uniform 45-day early voting period, which local governing bodies cannot alter, delay, shorten, or suspend without explicit authorization from the General Assembly. For the April 21st election, this period begins 45 days prior, consistent with state statute. Protection for election officials and voters. Virginia law strictly prohibits interference with election administration. Code 24.2-1000 makes it a Class 5 felony to willfully hinder or attempt to hinder election officials or their employees from performing their lawful duties. Code 24.2-1005.
We should stop. Is this still Ms. Garner? Is this still Ms. Garner's comment? I understand, but she spoke earlier, and that she didn't use her full 3 minutes then. So she has already spoke once, but I know she did not use her full 3 minutes in the original presentation. Yeah.
Okay. I apologize.
No, you're fine. She did not use her full 3 minutes, so that's why I was letting it go for a little bit.
Brenda Dixon, Poplar Pond Drive. Every resident can participate in saving our democracy. The very principle that defines America is based on fair elections. This should be a nonpartisan issue, reflect on the past in other countries, that allow dictators to rule. America is better than that. Gloucester is better than that. Let the people speak. Vote yes to protect the people's voice. Brenda Dixon, President. Legacy for Gloucester citizens. Nancy Pohl on Abingdon. Do not give any voting information to federal government. Keep voting rights with the states. David Helms, Bailey's Wharf Road. To the Gloucester County Board of Supervisors, why should Virginians be allowed to vote on redistricting? The proposed Virginia constitutional amendment would permit temporary congressional redistricting in response to actions taken in Texas, North Carolina, Ohio, and Missouri. In those states, legislatures acted without submitting the matter to voters. In Virginia, however, this question has been placed before the electorate. The Supreme Court of Virginia has made clear that this election shall proceed so that Virginians may democratically decide whether updated congressional maps will be used. As members of the Board of Supervisors, your responsibility is to protect the rights of your constituents, the citizens of Gloucester County. Your duty is not to have advanced partisan interests, but to uphold the law and ensure that voters have full and lawful access to the ballot. It is important to remember the legal framework governing your authority. You are agents of the Commonwealth. Under Article 7 of the Constitution of Virginia and the Code of Virginia, counties, cities, and towns are administrative arms of the state. Virginia follows the Dillon Rule, meaning localities possess only those powers expressly granted by the General Assembly. Election administration is governed by state law. Virginia law establishes a uniform 45-day early voting period. The Board of Supervisors does not have authority to alter, delay, shorten, or otherwise modify this period without express authorization from the General Assembly. Virginia law protects election officials and voters from interference. Code 24.2-1000 makes it a Class 5 felony to willfully hinder or attempt to hinder election officials or their employees from administering elections as required by law. Code 24.2-1005 makes it a Class 1 misdemeanor to intimidate, threaten, or coerce a voter or attempt to deter a voter from exercising the right to vote. The statute also provides voters with a civil cause of action, including the right to seek injunctive relief and attorney's fees. Additionally, the Gloucester County Board of Supervisors Code of Ethics requires members to place loyalty to the highest moral principles and to the county above loyalty to individuals or particular groups. The voters of Gloucester County expect their elected officials to uphold these standards. Any action that interferes with lawful access to the ballot will not go unnoticed. I respectfully urge you to protect the voting rights of Gloucester citizens and allow the professional staff of the Registrar's Office to carry out their duties in accordance with the Constitution and laws of the Commonwealth of Virginia. Do the right thing. Protect our vote by fully supporting voter access to the ballot beginning March 6th for early voting, with Election Day on April 21st, 2026. Very respectfully, David Helms, Sonoma, Virginia. Ann Williams, Qualified Lane. Dear Supervisors, please do not obstruct, delay, or interfere with a special election on redistricting. Everyone should have the opportunity to vote on this issue. Do not deny my vote or vote of others. James Bradbury, Coleman's Crossing Avenue. Gloucester County Board of Supervisors do not obstruct, delay, or interfere with a special election on redistricting. Do not deny my vote. There were a number of public comments received anonymously, which will not be read.
I thought there was one phone message.
Yes, my
One
name is
voicemail.
Jenny George, and I live in the Ware district. I'm here to demand that you do not block my vote on beginning March 6th for the redistricting proposal. This is something that other states have done, and it was not initiated by Democrats originally, but we do need to have a fair voice in the electoral process. Thank you so much. Do not block the vote. Thank you.
That was the last of them, Mr. Chair.
Okay. One last chance for anybody from, okay, seeing none. Oh,
My name is Ted Enquist. I'm in the Abingdon district. And a couple of things I just want to say. First off, thank you all for voting unanimous to suspend the license of people selling illegal substance in Gloucester and making our county much safer. Thank you. Also, I want to say that I'm here solely or mainly because of the passing of Howard Mowry. And it was not his right, but he felt a civic duty to be here. And so I decided to come out today because his funeral was earlier today, and we had a lovely time there. I also want to say, just comment on this, the whole thing with the proposal coming up for the 21st. And I'm not sure if you can add this to your amicus brief, but the very wording that's on the ballot indicates that what we have is not fair. That's what's not constitutional. The fact of the matter is what we have is the most fair. Matter of fact, the state of Virginia received an award from somebody, I'm not sure who it was, that this was the most fair process of redistricting that's ever been done. It was done by a board of both Democrats and Republicans. It was voted on by both a Republican-led Senate and Congress here in Virginia and also a Democratic-led, and it passed unanimous both times. Also, it currently is a 6-5 Democratic favor. But the fact of the matter is that the way that they redistricted, and it went through the courts in 2020 when all that was going down. And so the way that this thing came about was the most fair, bipartisan way that you could redistrict. And to try to take a county that is 80% or 85% Democratic in Fairfax and try to divide them up to 5 different districts is the most unfair thing that you could absolutely do. And so I think the thing that we need to do is not only challenge in the courts the constitutionality of this, because it's already in our Constitution to redistrict every 10 years, but also if it does go through, change the wording on that ballot and get the word fair out of there and just say what it is. That's all I have. Thank you.
Thank you. Anybody else? Okay. We will close public comment. We have no public hearings, and we will now move to our regular agenda. First item on our regular agenda is an ordinance to amend and reenact Chapter 22 Procurement of the Gloucester County Code. Mr. Ted Wilmot and Ms. Christine Joyce, our purchasing agent.
Thank you, Mr. Chair. The materials associated with this matter commence on page 11. Seems a lot later than that, of your agenda packet. As you are aware, periodically I come to you before the board with suggested revisions to your code, which comprises approximately, 22 or 23 chapters, one of which is procurement, which is Chapter 22. Mr. Bill Lindsay, who is a former purchasing manager, would come to the board periodically and recommend changes to your procurement ordinance. Localities in the Commonwealth are required to have a procurement ordinance or chapter. If they don't have one, they're bound by the Virginia Public Procurement Act, which means you have to abide by a certain set of rules and standards. However, counties and localities are given the opportunity to have their own procurement chapters, and Gloucester County has utilized that opportunity and enjoyed that opportunity by virtue of having its own chapter. Some of the provisions of the Public Procurement Act are required to be included, and we have those included, but not all of them. So you're allowed to sort of fashion your own procurement chapter to your own needs. And I think over the years, we've done that. So Ms. Christine Joyce is here. She is currently the purchasing manager. However, you'll see by virtue of the proposed amendments that she'll be changed to the purchasing agent. I hope that comes with a commensurate raise in salary, but it probably won't. But we do that. We do that because that's the the term that's used by the state code.
Correct.
So the proposed amendments here, and she can speak to them, and I think she has a slideshow which will fascinate all of us about the proposed amendments. There aren't many. You'll see them. They're highlighted in the dark areas are the changes. One of them I just alluded to. But it also offers some additional mechanisms to procure construction and procurement. So with no further ado, Ms. Christine Joyce.
Thank you so much, Ted. Good evening. I want to address the board. Thank you so much, Mr. Chair, and the members of the board. I'm Christine Joyce, as Ted had introduced me. I'm here to walk through the changes that we've been working really diligently on. I just want to remind you all that procurement is a primary way that we ensure taxpayers' dollars are spent responsively, competitively, and also transparently. Every contract we award and every project that we procure, it goes through this framework. So it's very essential. Tonight I'm going to provide that overview, and I'll get right into it. Let's see if I can figure this out. Okay. So you've been provided a full draft resolution tonight with the complete proposed ordinance language. My goal this evening is to clearly explain the updates. The agenda tonight, we're going to cover the overview, the purpose of the updates, the operational impact, and then we'll have some time for questions and discussions. All right, so what is our procurement ordinance? Ted already kind of explained it, but basically it governs how we purchase goods and services on behalf of the county and the schools. It sets our competition requirements, purchase authority, and dollar thresholds, as well as abiding by ethical standards. The full ordinance is publicly available on our county website, Chapter 22. So the big picture. We're updating our ordinance for really three main reasons. First, to align with Virginia state code laws that have changed recently. Second, to improve clarity. Also, to give us some better tools in our tool belt to strengthen some complex construction projects. It's important to recognize some things that didn't change. Competition is still required, transparency remains a priority, and of course our ethics still apply. These updates build on our procurement framework. We're not removing them, so we're just making it better. Role clarification, we're changing purchasing management throughout it for purchasing agent, and that better aligns with state code. The responsibilities of the role have not changed. It's just a accountability and kind of a best practice. So getting into another tool that I like to say for our tool belt is adding a new article which is going to allow us to use design, build, and construction management contracts. Previously, traditionally, we always have procured things, design, bid, build. So I kind of want to explain that tonight for you. Under design, bid, build, first, the county hires an architect or a professional engineer who designs the project for us. So that's construction, or contract one. Second, from that contract, they fully design our construction drawings and our plan set. We then take that and we procure the bid and we get a contract and construction begins. A good example of that was the recent project at Gloucester High School renovation. We hired Mosley, they designed the project for us, they guided us through the procurement piece, and then we got into contract with E.T. Gresham. So that's design, bid, build. Design first, then bid, then build. Design build works a little bit differently. Instead of hiring the designer and contract separately, we hire them as one team. They work together in one single unison. This approach can be especially good for complex, maybe fast-track projects or difficult site conditions. It gives us another option. We're not replacing anything. So the updated ordinance is proposing us to use that, as well as construction management contracts. Overall, it's going to give us more flexibility to select the right delivery method for the right project. Construction management is a slightly different model. The county would bring a construction manager on board to help coordinate the project, manage the subcontractors. The construction manager would typically perform a limited portion of that work, while most of the trades work would still be competitively bid. So competition's maintained. So some safeguards that I want to talk to tonight about using this alternative method would be the project would first have to be defined as complex. So we don't really use that loosely. And basically, a complex project would be possibly difficult site conditions, maybe some technical building systems that need to be installed, a tight deadline, and those are some examples. The second thing we would need to do is hire a professional engineer architect, and they would help us determine the best approach. Third, we would make a written determination that would be held in the procurement file explaining why we would go that route. These steps ensure the decision is professional, justified, and fully documented. So moving into a next update is our small purchase process. We're adding some more clarity here. So anything up to $5,000, that's not changed. That's our single transaction threshold. Multiple quotes are not required, but we still make sure this price is fair. Between $5,001 to $15,000, we're going to require at least 3 written quotes. This allows the department to move more efficiently while still maintaining competition and documentation. The smaller purchase range here is often where local vendors compete very well. Many of our day-to-day operational needs fall into this category, and local businesses usually are best positioned to provide that quick service for us and fair pricing. This structure allows us to maintain the competition while also creating more opportunities to work with local vendors. $15,001 to $50,000 is what we call our informal competitive process. This would be conducted by our procurement team, and we would use public posting when practicable. It's often called quick quotes, is what informal means. Over $50,000 is our formal bidding process. There's really no changes there. That's going to be your competitive sealed bid and your negotiations. These updates will help reduce confusion, create consistency across our departments, and improve compliance, but still maintaining competition. Our next update is emergency and exigency purchases. Emergency has always been defined in our ordinance, but we're adding exigency. So as you all know, an emergency is a threat to public health, safety, or essential services. Exigency is more of an urgent situation where delay would cause that emergency. It's important, I believe, to add this because it's going to allow us to move fast, especially when things happen that we know that we can't wait 30, 60 days for a competitive bid. A good example would be utilities. A water line is slowly leaking and we believe it's going to bust. We're going to want to move quickly. So we would have a written justification similar to our emergency. That way it is justified, explains why we're going that route. This will help balance speed and accountability. So a couple of our state contract updates, which prompted a lot of this, was any contract over $10,000, we must now include no forced or indentured child labor. And as you can see on the slide above, all of the other ones still apply. So we're adding one more to it. Our information technology contracts, state law changed that no other state can use law outside of Virginia. So this one's very important. As you're aware, a lot of IT contracts contain a lot of complex legal terms, and this ensures that Virginia law always applies. In summary, these updates will help modernize our procurement ordinance, and they will help add controlled flexibility for our complex projects, improve clarity for our small purchases, as well as strengthen our labor and compliance standards, all while maintaining transparency and competition. Overall, they will make our procurement process clearer, stronger, and better equipped to support the county. And in conclusion, I want to thank you all tonight for your time and attention. I appreciate the opportunity to be here with you. And as noted, the resolution adopting these amendments is included in your packet. I respectfully ask for the board's consideration. I'm happy to answer any questions you may have.
Dr. Orth?
Yeah, great. Thanks for that presentation. I think in the past that term design build has come up frequently in some of our projects, but we didn't have that opportunity. So the design build process would facilitate the construction, correct? And would lead
Yes.
to more efficiencies and hopefully a lower price, correct?
Correct.
Would the current new firehouse fall under that possible?
It wouldn't at this point because it really has to happen at the birth, right? So before the design phase. But essentially, it could have if we were involved in the design from the beginning. But that would be an example if we did something of that nature in the future.
Okay, thank you.
Yeah.
Dr. Leming?
I'm going to dovetail on Dr. Orth's comment, I think, not with regard to the fire department, but with regard to the better use of taxpayer dollars. I want to make, it's not a change, by the way, I just want to amplify a section in the current code that I hope we're going to reaffirm. But the county supplies purchasing agent services to the schools as well.
Yes, sir.
And I don't know that everybody always knows that, you know? And I think that's a compliment to the way the county administration and the school administration work with one another to try to bring the highest and best value to everybody's taxpayer dollars. And I just want everybody in the room to acknowledge that that's an area of really daily cooperation. And I just want to compliment you and bring that out as a highlight in tonight's meeting. Thank you.
Thank you, sir.
Mr. Hutson?
Ms. Joyce, I do have a question on page 28 about the child labor laws.
Sure.
If you were providing a product, and I see your two kids are with you, under 18, and they had to work with you to finish the screen printing, the T-shirts, or whatever else, and you told them that they weren't eating until they were done, would that be the same thing? I mean, actually, I thought about that more as if somebody was doing a job, if nothing but if we didn't have grass cutting, and they were working with their parents. I mean, is that excluded from that? I mean, I'm serious. Is that excluded, Mr. Wilmot?
Thank you so much for your question. We're putting this in there because the state requires it, and that's verbatim what the state requires. I don't know the answer to your question.
So then my question is, what happens to the jobs under $10,000?
They're going to work.
Not required.
They're not going to eat till they work. But, I mean, I'm just wondering how that affects, that if they're helping their parent.
Yes.
Having experienced a situation where my child's work permit was revoked, I have a little bit of experience with this. When, so the state does have laws about under what circumstances, what hours, and what fields, but there's an exception if it is your own child. So it was kind of like if they're working for you, it's a different situation than if they go to work for somebody else.
Right, because I never had to have a work permit working for my
But I mean,
father.
I'm just looking at,
I'm more worried about
The under
the
10?
the under $10,000 where you could have all 15-year-olds building something. I mean, right.
I mean, well, they probably couldn't cut grass, but that's why I said they could screen print, but.
Mr. Chairman?
Yes.
I move the resolution.
Is there a second? We have a motion, we have a second. Is there any further discussion? Seeing none, Ms. Steele, will you pull the board?
Mr. Hutson?
Yes.
Mr. Chriscoe?
Yes.
Mr. Nicosia?
Yes.
Ms. Hanson? Yes. Mr. Bonniville?
Good job,
Dr.
Carolyn.
Orth?
Thank you.
Dr. Leming?
Yes.
Thank you all.
Thank you very much. Great job.
Jeez.
Okay, next up, we have a consideration of zone ordinance change for small sheds. Ms. Carol Steele.
That's a hard act to follow with the applause and all that.
Bet you don't get that much
No,
applause.
no way. Before beginning into the topic that's in the board packet, I just wanted to mention at the previous meeting, we brought up this, we had postponed this topic, but we brought up another one about potentially having a waiver for after-the-fact fees for building permits. And I wanted to let you know that independent of these meetings, we were able to work out that situation, and so there's not going to be a follow-up or request to that situation.
Thank you.
So tonight, because it's been brought up before, with whether it's confusion, lack of information to the public, people, because they don't know, breaking the law, a lot of reasons, or violating the ordinance, I should say. But anyway, this topic came up, and there's a good amount of background information. And the first thing to make sure that we're clear on is that we are talking about zoning permits only. This is not dealing with building permits in this discussion, as far as if they're over 256 square feet, they're required to get a building permit, period. And if they have trades, then that's another thing. The questions that we have had are on our zoning permits, and if you look at page 78, there's good background that explains that there's a $35 fee, and we talk about sheds, but in the ordinance, it's also talking about accessory structures. But for the general public to understand, we really wanted to put it simple. I was going to say dumb it down, but I don't mean that. Put it, talk in a simple terms and say, we're talking about sheds. And so these are for the people who go to the Home Depot, the Lowe's, the places on the side of the road, and they purchase a shed, and they may not be aware of the current ordinance. So if the board is interested in changing the ordinance, we'll pursue that as appropriate. If the board says it's fine like it is, nothing's perfect, this works, either way, we want to do a public education campaign, and we want to do it at the places, in addition to on our website and things, but at the places where people buy sheds. And so the idea is that the ordinance was put into place because we have people who might innocently buy a shed. They don't know they're supposed to have a zoning permit. They put it up, and it's either, it could be in the RPA, it could be in wetlands, or it might be within the required setback. And that's not something that people, general knowledge, that are going to have in mind. When they come in to request the zoning permit, which is $35 flat fee, that's all it is, $35, they are required to produce a scale drawing to show that they're not putting the structure down in the setback area. And some people have complained about that. Sometimes it's easy. They may have a plat of their property that they can use that's got the scale on it, and that's something that they're handy at. Staff have helped where possible, where if we can pull something down from our own system internally, we'll do it and print it for them and give it to them. And then for those who don't have a situation like that, they're asked to go out and just measure in their yard where their boundary line is to where the shed is, and put that on a drawing, and so that it's a scale drawing. They're not being asked to go get an engineer's stamp, but still some people find that a little bit more difficult. Not the perfect answer is if the board says, maybe this is too burdensome, why don't we just not have this requirement, and the board decides to make an ordinance change. We still have the setback requirements, we still have RPA, and we still have wetland requirements. So if you take this ordinance away of making them get a zoning permit, people may put up a shed, put it in the wrong place. We are complaint driven. There's no pre-visits or post-visits of inspection. It's a matter of the person defining it, and we trust that this is the way it is until we hear differently. But if they, and I lost my place on that, sorry. If they don't know, and there is a complaint, then the inspection is done, and they might not have the ability to pick the shed up or deal with it and move it. And so they may also be saying, this isn't fair, I didn't know this, nobody told me. So that's why I said either way, we want to do a public education campaign. So you have on the one hand, the hassle, the $35, the getting the scale drawing. On the other hand, we have records that we also need to have for when these zoning laws change. And if this process is stopped, we're not going to know when somebody put something down and be able to keep them under the law that was done at that time and some of the other kinds of things that might factor in, because these codes do change occasionally. So Ms. Ducey-Ortiz provided some good information on statistics. So, what are we talking about? I have no idea how many sheds are sold within the county, but I believe it's quite a few each year. I think they're pretty popular. They don't last forever, so sometimes people are out replacing ones too. So she had 81 zoning permits, or they had 81 zoning permits for sheds in 2025, and 13 of those were issued after complaints. So the person had not applied for obtained the zoning permit, and a complaint was filed, and they were determined that they needed to do that. So it was an after the fact on that. Of the 81, 54 were for sheds that were under the 250 square feet dimension. And again, if it's over 256, they have to have a building permit anyway, which is going to kick them, and they're going to get a zoning permit with that as well. So these are only for smaller sheds. And 54 of the 81 were in that smaller category. It's also noted that they have 6 outstanding complaints from a total of 9 complaints related to sheds. So people do call on their neighbors, people do notice things or feel like they're encroached upon, and those kind of complaints do come in. So Ms. Ducey-Ortiz is here, I'm here, anything that we can do to provide the board with additional information if you would like to consider making any changes.
Mr. Chairman.
Dr. Leming.
Ms. Steele, this is a topic near and dear to my heart. I've forgotten the exact year, but it might have been 2014. My wife and I rebuilt a home next to our home, and my daughter was living there. And she decided to get a shed. So she actually was able to get a forklift big enough to bring the shed onto the property. Didn't know anything about setbacks. She didn't have a zoning permit in 2014. She had nothing. It was under the 256 square feet, and life went along just fine until one of the neighbors became irritated at my daughter and called the county, who came out and delightfully told us all the shed was 5 feet off of the setback, off of the property line, because they were trying to put it right up against the property line. So it was a big brouhaha, to be honest with you, that probably could have easily been avoided. And let me promise you, from personal experience, $35 and getting a zoning permit was worth the private war angst that went on in between neighbors. And by the way, we were able to get a forklift big enough to go down there and pick it up again and move it to a different parcel on our property where it's appropriately set back. But if you want to know what I really think is these rules ought to be stapled to the sheds where they're purchased. Because that's where people kind of walk around and they go, it'd be really nice to have another shed to put my lawnmower in. My other shed's all full. And it's almost, not everybody, but a lot of people, it's almost a knee-jerk decision right then and there. And if they saw it posted on the shed they were going to buy in Gloucester County, you must have a zoning permit to place this shed on your property. Otherwise, everything's going to be after the fact. And all I can tell you is it's just such a nightmare. Thank you, JJ, really and truly. And we were all upset about it. It was done completely innocently. It was never meant to irritate anybody. But I'm not opposed to the current process. I am completely in support of some kind of a public education. But I meant what I said. We ought to require the businesses to staple it to the sheds. Wherever they are in the county, there's Shedman, that's probably in Middlesex or King and Queen, Shedman. They're just over the line on County Drive. And then we have the big box stores, but that's sort of my personal experience with this, and it wasn't great. Not with the county, by the way.
Any other comments?
I think that requires a building permit.
The reason this has come up is, if you look, there you have 54 sheds under 256 square feet that actually applied. I can't imagine what the number is that do not apply. So this is one that it's great to know, and I read this information again, and it rears itself up every so often. And funny, I'm the one that brought this up, and then I'm looking at all this and I'm going, yeah, it makes sense in your situation. I don't think we can require these companies to put anything. I think it would take a effort to reach out to the ones in the county. Unfortunately, I know there are probably quite a few folks that order these from somewhere else that come inside the county that we'll never catch. I'm fine with leaving it alone. I think at some point in time in the near future, though, we probably need to address that getting a zoning permit for your sign costs more than a zoning permit for your shed. But that's for another discussion another day. But that being said, I'm thankful for the 54 folks that actually did what they're supposed to do. But with that, I don't know what the board's inclination is. I think we just leave it alone for now.
Leave it alone to educate.
See if we can do more. And honestly, I think we need to adjust that $35 to, if we got to get a zoning permit. I see on the fee schedule here, we have a zoning permit excluding signs and a zoning permit for signs. I'm sure Ms. Ducey Ortiz would appreciate if we have a zoning permit as a zoning permit. So we can look at that in the future, maybe.
We'll add that to the next list to talk about. And we do want to make the process in our marketing easier, because even if you go online, which I've done, taking the steps through trying to find how to get a zoning permit for a shed, it's not easy. And so we're hoping to create a specific web page with a QR code so people can just zap it and know what to do then. Thank you very much. Appreciate
Thank you.
the input.
Okay, next up we have board appointments. Get to my sheet here. And we're on page. We have open a vacant spot. Oh, yep, Mr. Hutson.
Y'all didn't clap for Miss Steele. Come on.
Very well done.
Okay, excuse me.
Yes, no, well done. We have Board of Equalization that has remained vacant. We need a real estate building finance professional. Where's my pink sheet? Do we have anybody? No. We have Clean and Green Advisory, 2 citizen reps. One, Ms. Moscow wishes for reappointment, and Ms. Regal does not. Do you make the motion to appoint Amber Corm? Do you make the motion for Ms. Moscow?
Yes, both.
Okay. We have, is there a second? Second. We have a Comprehensive Plan Steering Committee vacancy in the Ware District. Mr. Nicosia, have you talked to anybody, or?
I will work on that.
Okay. And Parks and Rec Advisory Committee.
Local emergency.
Did I miss it? Oh, yeah, I'll take care of Mr. Casella. Can you work on that one? Okay. Local Emergency Planning Committee, Mr. Giselle. Mr. Hudson's made the motion. Is there a second? And then we have a Tourism Committee. We actually have someone who has applied for that on here. Would someone like to make the motion for Mr. Newland?
So moved.
Is there a second? Second. Okay, we have Ms. Mosca, Ms. Quorum, Mr. Gazelle, and Mr. Newland. All in favor, please signify by saying aye. Aye. Okay. Mr. Wilmot, County Attorney items.
No, sir, just glad to be here.
Thank you, sir. Yeah. Boards and commission reports. Supervisor discussion.
Feeling okay?
Yeah, I'm fine. Remember,
I thought you thought you would bring that up.
so I want to make, although I told her that we're not required to do so, I'd like to just say, I think Ms. King, who made a presentation to us and who put this together, I think Ms. King is in an odd spot. As I understand the matter, the property was vacant for a substantial amount of time when she and her husband purchased the property. It is unclear to me that she realized that it had been vacant and it had lost its vested rights. That is unclear to me. When she contacted, what she didn't tell you was when she contacted the power company to turn the power back on, the power company is supposed to clear that with the county and failed to do so, and they re-energized the power at her second trailer. At that point, I think she sort of thought life is good. She and her husband reportedly retained a licensed electrician to do some electrical upgrades. I don't know that they were permitted or inspected, quite frankly. And I think they wanted to put a structure on the front of the building as sort of make a home office or something, and that triggered their desire for a building permit, and that triggered the whole cascade of, well, you now own by a month a structure which has lost its vested rights and is now a non-vested, non-conforming structure. In fairness to the Kings, and I did go out there, just so you know that, in fairness to Ms. King, she basically, on the property, as you drive up to the property, there is just a dilapidated trailer. It would be one of those things, Ms. Steele, that I would call a blighted property, that I am struggling to get an ordinance somehow to get rid of these things. And Ms. King has actually proffered that at their expense, without an ordinance, they would like to remedy the blighted property. I saw that as an improvement to the neighborhood potentially. And she's right, and in fairness, Ms. Anducci-Ortez has been clear with her, she's been very clear with me, and I think she's been fair with Ms. King. There really is no remedy at the moment to this problem. 2 years, she loses vested rights, really and truly without some action from the board's point. She has an option. She can buy another piece of agricultural land and move the mobile home there so it could be used by right. I think the current zoning is SC1, I think I'm right. And mobile homes are not permitted in SC1. She could just tear both of them down and trash them and build a stick-built place there. That's probably cost prohibitive to her, I don't know that. But she basically said, I didn't know anything about the $2,000, just so the board knows that. But she said to me she would be willing to proffer removal of the bad trailer. She'd be willing to proffer to have the electric inspected. She'd be willing to have whatever appropriate building permits were needed and have those inspected. Put a foundation under the thing, which she represents, and I don't know factually, but she represents that if she puts a foundation under it, that it transforms it from personal property to real property, which could then be taxable as real property. And now she's proffering an additional $2,000. I have said to her, and I've said to Ms. Anducci-Ortez, and Ms. Ortez has also suggested to me that we don't like to do spot zoning. And I don't like to do spot zoning. The matter did come up about sort of a fairness conversation, and that is that if perchance it had burned to the ground, the vested rights would have extended for 5 years, but then the vacancy vesting expires in 2 years. And Ms. King, and I don't mean tonight, Ms. King suggested that perhaps the board might be willing to extend the vacancy vesting rights for its consideration. I thought she had a reasonable, she was very reasonable dealing with me. I think she was reasonable dealing with Ms. Ortez, and I thought she had a good presentation tonight, and I don't have an answer.
Steele.
Can I check with the county attorney on this? The 2 years is a state law, not a county. I mean, it's.
Localities are required to allow the 2 years. Localities can extend the 2 years.
So that's what I was going to ask, is there an enabling?
But 2 years is the minimum, and that's what we do, and I always hesitate to suggest, recommend, or support an amendment on the behest of one person.
Right, okay.
And in fairness to Mr. Wilmot, it was echoed in my ears when I was speaking with her about that, and I represented that to her as well.
Mr. Nicosia.
Chair, if I may cover just two things. One thing, I feel inclined to say, after some discussion, that some of my comments at their last meeting about who pays for the county's water and who doesn't pay for the county's water, we all pay for the county's water. So if I indicated to anybody out there in public land that I don't feel like everybody's doing their part, that is not at all what I meant. So let me apologize on my own behalf if that's how you felt, and I am sorry. Second of all, Mr. Chair, I personally, and I heard his name mentioned in public comments, I want to express to Mr. Mallory's family, on behalf of myself, his passing. Mr. Mallory and I would jokingly say we will never see eye to eye. However, Mr. Mallory and I got to share a very special connection because I understood in our conversations where he was, as far as when he got that $1 million scooter. But on behalf of my family, I would like to express my condolences to the Mallory family and extended family for the passing of a very faithful citizen, whether he agreed with us or disagreed with us. He proved to the citizens of Gloucester what civic duty is really all about.
Man, I know it's not my place, but I was derelict. I 100% agree with what Mr. Nicosia said. Wonderful person, and I will miss him tremendously.
Yes. We all will. My plan was to do a moment of silence at our next budget meeting on Monday because it'll be the first meeting he hasn't been at to a budget meeting to tell us what we need to do with the budget. So that was my plan, was to do it next Monday, and we'll still do it.
Since he's been gone.
Yes. Mm-hmm. If it's possible, and I know Mr. Wilmot has said that, and I know he likes to craft his memos. Between that, I would like, this is one of the ones that really, with the Ms. King proffer here, it's one of these things that we've had it come before us several times since I've been on the board about a building that has lost its vested right for whatever reason. I'd like to get us some more information again, and you can probably just resend what you've sent to one of the other countless times, Mr. Wilmot, to refresh my memory because unlike you, I don't remember the code sections and everything else that I need to, but I would like to receive that information again if possible. Because I know we're dealing with a similar situation with a child care center and a SC1 district, everything else. And just to get that sent back would be helpful.
I can do that, and I will do that. But what it will entail is, as I indicated to Ms. Steele, that localities are required to allow this 2-year grandfathering, but you can extend that. But it's sort of, unfortunately, a one-size-fits-all thing.
Correct.
So non-conforming uses are uses which are not allowed now, but which were allowed previously. So they're allowed to continue if they're uninterrupted for a 2-year period. And after that, the law disfavors continuation of non-conforming uses.
Correct.
Because your zoning ordinance is, you've decided this is what we want and this is what we don't want. So you don't want, apparently, or the board, when I say you, previous boards, don't want this manufactured home or trailer. You don't want that. So when it's been discontinued for a period of 2 or more years, it loses that vested right, grandfathered use, and it's no longer allowed to continue. You could extend that, but if you extend it, you can't do it in an individual place situation, because that's spot zoning. You can't do that. You're not allowed to do that. $2,000 is out of the question. We don't get paid. No, we're not allowed to take that. We appreciate the offer, but we're not allowed to take that. So you could extend, and I will share with you my previous correspondence on that. But please, I urge caution.
Correct.
Because if you've decided, meaning you, the board, that you don't want a particular use, whether it be a vape shop or a manufactured home, if you don't want it in that place,
Correct.
then the 2 years is the minimum period of time that localities are allowed to cut off, which is 2 years and 1 day, they're not allowed to reinstitute that use. So I'll share that with you, but please, I urge caution.
No, I just want to see it again. Mr. Hutson, then Dr. Worth.
But Mr. Wilmot, if we were to change anything now, we'd have to do it retroactively to take that into consideration, wouldn't we?
Yes, sir, and you might be able to do that, but it wouldn't be in this one case. It would be
for every case.
It would be, and you did a recent case, I think, at the behest of
Mr. Smith.
Yes, Mr. Smith. But it wasn't spot zoning because it was something larger than that. Spot zoning is where you only benefit one person. That's really what spot zoning is. Some people think spot zoning is if you rezone one piece of property, that's spot zoning. No, not necessarily. If you can attach that rezoning to a larger benefit, larger than one person, then it's not necessarily spot zoning. It's a factor. But yeah, please be careful.
I'm not asking to do anything. I just want to see the information. Yes. Thank you. Dr. Wood?
Let's see how we can help her. I mean, I know. I feel. I know.
Right. It'd be nice to be able to help.
I'm a lawyer for the government. I'm here to help.
Right.
I will say on her behalf, I said, well, because I didn't have the ability to do this, I asked her to reach back to Dominion and find out exactly when the power was cut off and when the power was cut back on. And forgive me, I think if she's still here. We were off by a month.
It was the correct date, yeah, it was August 2023.
Right. So your 2 years in a day were actually 2 years in a month.
Oh, even worse.
Right. Ms. Hanson? Mr. Bonniville, anything else?
Yes. As you know, I'm in the Hampton Roads Peninsula Planning District Commission. 2 bills are actually being heard right now and have not been heard that I think can affect our county. I've talked to Ashley about this. One of them is that they may force us to increase our affordable housing by means force. And that is not what one community can do and other communities can do, and what that looks for each community can have a grave impact. I mean, affordable housing is important, but when you're having an unfunded mandate, as they say, those things can be very hard on communities when you're already dealing with budget constraints. The other one that I'm concerned about is that they may remove or limit our ability to limit solar panels or alternative energy. So right now we have a cap that we've set, but the amendment that I've understood was that that would remove our ability to do so. And that means that Dominion Power would, or any energy company would be able to just basically, if a landowner wanted to do that with their land, we would have no restrictions on that. And I believe the restrictions are good for us right now. I'm all about land use, and personal people having their property and using it as they will. But, you know, a lot of people, some people are desperate and they want money, they need it, and it not necessarily be the best thing for the community. So those were two things that I got out of the last meeting that I thought I'd bring back to the board members and say, you know, we need to be on the lookout for that, because that can impact us quite gravely financially, and as a community have an environmental impact that we may not be able to recover from. So that's all I have.
Okay. Dr. Leming?
Mr. Chairman, one last item. I heard my colleague talk about the capital improvements tour we did recently, which I thought was interesting. I have to say Ms. Legg probably provided the most entertaining part of the tour and the most educational part of the tour. And I think when I came away from there, I was struck, I think I've paraphrased it to my wife in the following way. I was struck at the largesse of the need. I'm going to say that one more time about the utilities department. When you actually go put boots on the ground and you look at the equipment that's there, I think it's circa 1978, correct me if I'm wrong with the date, you are struck truly with the largesse of the need. Mr. Chairman, in my previous locality where I served, we too were struck at times with the largesse of the needs, and we retained a fraction of a federal lobbyist to help us get our capital needs before federal subcommittees in the budget. And I took the opportunity to ask two firms, I haven't heard back from them yet, two firms to perhaps put a presentation future for the board about what they might be able to bring to our county in terms of services and what it would cost. The presentation would obviously not have any fiscal impact. But I'll tell you, from my previous experiences, there's a lot of federal money for water treatment plants that's available just in that topic alone. And the largesse of that need is just, Mr. Nicosia always says, what's the one thing that keeps me up at night? It's the utilities. And I've been up, that's the one thing that's had me up recently. So the two firms are Alcalde Fay and Thor, Thor, and hopefully we'll be able to offer a presentation at a date future out of budget. You know, this is a conversation later in the year, but I just wanted to bring that to the board's attention. Thank you, Mr. Chairman.
Anything else for the...
And thank you, Ms. Legg.
Anything else?
Actually, it was the part of the tour I really wanted to go to, but I was sick, Katie. So
I'll give you a personal tour.
that would be lovely. I would love that. Thank you very much.
Mr. Hutson?
So moved.
Is there a second?
Second.
All in favor? Aye. We are adjourned.
Praise the Lord.